Mic check, mic check. Cool. What's up, everybody? What's up? Mic check, mic check. Uh, um, I'm trying to see if I'm actually, yeah, that should be the thing that's, yeah, let's just do it. There we go. There we go. There we go. All right. Making sure I post on YouTube. What's up, everybody? What states? What states? YouTube house. There we go. Let's pull out the chat. There we go. Beautiful, beautiful, beautiful. All right. What's up, everybody? What's up? Let's close that out. Let's get my stuff right. Let's get in order here. Uh, let's go to the Constitution. What's up, everybody? What's up? What's up, Diddies? Um, let's close that out. What's up, everybody? What states are we from? We got South Carolina. Let me see. Exit out of that. Let's exit out of that. Gotta keep the Constitution there. Declaration of Independence. Bill of Rights. All right. Let's see what South Carolina has to say. South Carolina. What's up, everybody? What states are we from? What states? Montana's in the house. Let's go. Montana. I actually love Montana. I spent like a summer there, and that was no times of my life. I thought that was the coolest place. It wasn't the summer; it was the spring. So it still snowed every now and then, but it wasn't crazy. It was outside of Billings. I think it was called Roundup, Roundup, Montana. That's the smallest town I ever been in, and no phone service. You have to download Google Maps offline before you act like you know where you're going. We're driving on like the side of this mountain thing. I'm like, no, this is not great. Montana, you're 75 miles from Roundup. Let's go. Yeah, and Roundup, they literally had like one crappy hotel, one grocery store, one gas station. It was outside of Billings. I do that. And then that's where we stayed. We worked somewhere. I couldn't tell you the name of that place, but Montana. Let's see what we got on Montana. Here we go. The Supreme Court of Montana said, uh, so you know that main strip. There's a main strip. There's like a bar at the end of that strip. There's like a bar, post office at the end of that main road. Is it Clinton? I don't know. Actually, I can tell you from Google Maps. I have all my stuff saved on Google Maps in case the Illuminati wants to track and find me. Let's see. Let's see. Roundup. I took a picture of. That's Montana. Let's go up to Montana. Yeah, here we go. There's Roundup. Roundup, yeah, it's got one main street. It's called Main Street. At the end of Main Street, we ate at the back porch. Uh, no, I think we were at Keg Bar. That sounds more like it. We ate at some bar. Yeah. And then the hotel was Autumn's Inn. I think that was it. That's like the only hotel in that whole town. But we worked in, let's see if I got Maelstone, outside of Maelstone and outside of a Maelstone. We're in the, I don't want to call them mountains, but you know, they got crazy hills up there. So that was outside of Muscle Shell. We worked outside of Muscle Shell, which is all the same place. So that's all the main strip. What's that street? 12, Highway 12. We were all up in there. Yeah, I thought that was so cool. They got buffaloes all on the side of the road. Yeah, but it was outside of Billings. You can take 87 on up. You could take 2 ways up. We took Highway 3. Highway 3 was, like, crazy. It was like 'cause it sucked. But yeah, Montana. Okay, so the Supreme Court of Montana said that the common law of England is the rule of decision and courts of this state. Supreme Court of Montana said the common law of England is the body of jurisprudence as applied and modified to the courts of this country up until the time it became a rule of decision in this commonwealth. They called themselves a commonwealth. Look at that. So yeah, the Supreme Court of Montana. What else do I have? Ooh, Montana's got land patent. The Supreme Court of Montana said that a land patent is the highest possible evidence of title. They said when a patent for public land is issued by proper authority, that patent is not open to collateral attack. That's insane. So you get your land patent, and they said it's not open to collateral attack. Now that don't mean them attorneys ain't gonna try. They gonna give you a fight. They gonna run for your money, but you learn the law on land patents, and they don't have to leave you alone, or they're gonna pronounce a judgment against the land. Everything that I've read says they'll act like they sold it. They'll act like a tax sale, and then when whoever bought it tries to insure it, tries to um, tries to insure the land or the property, and it was something else. They try to do 2 things, and those 2 things they can't find the land in order to insure it because it's not on the public domain anymore. That plot of land is not in the public domain, and if it's in the public domain, they don't have a way to attach to it. So, yeah, it was like, you gotta take a loan out on it. You can't take a loan out on it, and if you try to insure it, there's no way to insure it because once you get that land patent, it takes a plot of land out of the public domain. Yeah, that's the Supreme Court. Now, this is what's hilarious. So they say this land patent is the highest possible of a title. They said a patent for public land is not open to collateral attack. And they cite 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, no, no, 16 Supreme Court cases, state and federal Supreme Court cases saying that land patents are not subject to collateral attack. That collateral word is a commercial term. So yeah, um, Montana. Let's see, I don't know if this is, and then I got some other stuff on Montana, false imprisonment, all type of stuff. All right, South Carolina. I didn't read this the other day, but they said the Supreme Court. I don't know why South Carolina's mentioned here. Oh, okay, okay, okay. They said there could be no acquisition of territory made by the United States distinct from and independent of the states. They said when referring to South Carolina and Georgia, each declared itself sovereign and independent according to the limits of its territory. The soil and sovereignty within their acknowledged limits were as much theirs at the declaration of its independence as at this hour. It said states are sovereign and independent. What is false imprisonment? The Supreme Court of Montana said that false imprisonment uh, is treated as a tort and also a crime. They said the definition is the lawful violation of the personal liberty of another. False imprisonment is the violation, the unlawful violation of the personal liberty of another. They said false imprisonment may be committed by words alone or by acts alone. They said they're citing the Supreme Court of Kansas. They said false imprisonment is necessarily a wrongful interference with the personal liberty of the individual. They said all that is necessary is that the individual be restrained of his liberty without any sufficient legal cause, therefore, and by words or acts which he fears to disregard. So does that mean anybody from South Carolina is a sovereign by way of the law? You are considered sovereign because you are not supposed to be subject to another or foreign government. So you could be sovereign by virtue of the state being sovereign. I would be careful using the word "I am sovereign." No, that's not how that works. But that applies specifically to that piece of land and those who were born on that piece of land. Now, if you move there, that's equivalent. That's what they call naturalization. So, yeah, that could be applied. How does it work properly? You don't have contracts. You know the law. You learn the law, and you live the law. That's why we're talking about the law, so we can know the law. Montana. So if I ask you what's the law of South Carolina, because they just said it, right? They just said South Carolina is its own thing. The common law of England. Okay, so what does that mean? That gives us the responsibility now to go start knowing the common law of England. um, the South Carolina Constitution creates government, and then the common law of England is how that government is to operate. And that's the thing we're supposed to live by, but we're all supposed to know it. So at the end of the day, law is history. That's what's important. They want you to think law is brand new. They made it up yesterday and you have to magically do what it say because they wrote it down on a piece of paper. That's not how law works. Law is invisible. There's no such thing as we wrote down the law. Even in the Bible, people and these statements aren't wrong. They say the law comes from the 10 commandments. That's cool. I don't disagree with it, but that's not the law. That's not where the law came from. So I seen a video the other day. They got this thing where they're outlining the books of the Bible and they say the first 5 books of the Bible, that's the law. No, that's not the law. The law is technically just in the book of Genesis. And then you can see the rest of up until you get to First Samuel. them either obeying or disobeying the law. And then after that, so technically, if I was, I'm nobody, but if I was to structure it, okay, I'd say the first book of the Bible called Genesis is the law. And then after that, from Exodus to First Samuel is how they lived or didn't live according to the law without a fictitious corporate government. And then once you get to First Samuel, all the way until the New Testament, I think is it Micah or Malachi is the last book of the Old Testament. Okay, you're going to see what life looks like with corrupt, fictitious governments. And then you get to Matthew, Mark, Luke, and John, and then you're going to see Christ fulfilling the law and the result of him fulfilling the law is that people don't have to live with fictitious governments anymore because Christ fulfilled the law. That's why they don't talk about him. Not for real. And that's why they don't talk about his resurrection. Not for real. Because Christ said all of the law. How much of it? All of the law and the prophets are talking about me, Christ, not me, but as if he said that's what the law is about. He said the Old Testament it is about that we as regular people cannot fulfill the law. We're not perfect. We're going to disobey it. We're going to disregard it. We're going to ignore it. We're going to go in the complete opposite direction of it. So Christ came, removed his divinity, walked in human flesh, and obeyed and fulfilled the law. So when he gets to it, he says, "Oh, well, the law's about me." He said, "I did it. I'm doing it. I am the law." And then you get to the New Testament, and then you see the reality of people either not obeying the law or not recognizing that the law is fulfilled. There's a verse, there's a big like in the church world or in the Christian world, people debate this. They say, "Oh, well, the law was done away with." The law was not done away with. He said not one word or letter will come to pass until the law is fulfilled. And then he said he fulfilled the law. So there's the what I know this is weird, but the law is Christ. That's why they don't talk about him. They say it repeatedly in these Supreme Court cases. The common law of England comes from the scriptures. You're like, well, that's a weird thing to say. And then they said the common law of England's not written. It's invisible, right? And so you have to literally study history. They say in the definition of the common law, they said, okay, the common law of England, the first thing they tell you is that it's not written law. It's not legislative enactments. It's the opposite of legislative enactments, right? Okay, that's the first thing they tell you in the definition. Then they say, okay, well, since it's not in legislative enactments, then where do you find the law? Where do you find this common law of England? They say you'll find it in the book of reports, where they just chronicleize history and explain, and not necessarily that it's in the book of reports, is that you'll find them in the book of reports. You'll just find a piece of history where at this point in time, this is what the people did. Not the government, the people. The people did this. And then you'll find that principle in there, and then that will be an explanation of the common law. They said it's not on legislate. They said that's not the law. What's the Bible? The Bible is a book of reports. The Bible's not the law. The Bible's just where you'll find it. You'll just see what people reported. It's not a scientific document. It's a historical document. That's just what happened. They just reported it. And then over the years, somebody compiled the information. That's all that is. Well, it's no different than today. One day, 1,000 years from now, somebody's going to find the South Carolina Supreme Court reports. And they're just going to read and say, oh, this is how the people did this. Oh, this is how the people did that. Oh, they adopted this thing called the Magna Carta. They're not going to know what the Magna Carta is 1,000 years from now, but they'll know what a South Carolina is if they hypothetically, and they'll say, oh, well, apparently these were the principles in, okay, that's what they did with the Bible. It's the same thing. Right? They're just giving you reports of historical things that happened. You can believe them or not believe them, but it's just history. That's all it is. I'm not demeaning that. I'm saying that is the significance, is that when we talk about this thing called law, you're just finding the significance in history. They can't write law. There's no such thing as writing the law. I know they say that, but that's because they want you to believe them. Right? So what is the law? The law is invisible. Technically, the law has always just been audible from the book of Genesis. I told you, that's where you'll find everything. They said in the book of Genesis that Abraham obeyed the law, obeyed the commandments. What command? There were no commandments in Abraham's day. But every time in the book of Genesis, they'll say the first thing you see is the relationship between Adam and God. And they'll say when Adam committed the first sin, him and Eve committed the first sin, it says that God walked through the garden and was looking for Adam, like in the cool of the day. He's like, well, I'm normally down here and Adam's normally here. Not, I'm being sarcastic. And Adam's not here. And so he says, Adam, where are you? He don't say it like, I lost Adam and I can't find him. He's asking Adam so Adam can find out where he is. So he says, well, yeah, I'm walking around in the cool of the garden because this is where me and Adam normally commune. When I created Adam and I put him in a garden, I gave him the law. I said, you till that ground, you name every creature, you have dominion over the earth. That was the law. They call it natural law. What does a farmer named Adam do all day? He plants seeds, he tills gardens all day. He learns the principle that Christ taught in the New Testament called seed time harvest. That you reap what you sow. You put your hands on somebody, somebody's going to put their hands back on you. You damage somebody else's property, they're going to get their get back. You know what I mean? This is natural law. People tell me all the time, oh, well, trust law is the hardest form. No, it's not. Trust law is fake. It's not real. It's a fake piece of paper. That's what the serpent in the garden tried to do. He tried to establish a contract. He said, if you do these things, you take a bite of that fruit and you'll be like God. But they were already made in the image and likeness of God. Right? So all these people talking about trust law, no clue what they're talking about. He said, I used to walk around in the garden with Adam every day. We used to come down, have coffee every day at 3:00. Adam, where are you? One day I'm down here walking in the garden and there's no Adam there. Right? Okay. So that's Adam and God, right? So they make it seem like, okay, well, Adam used to walk with God. And then you get to the next picture. There's this guy named Noah. And they said that Noah walked with God and obeyed the law. Then you get this guy. I got it. Actually, I got this. I found out every time they said Enoch, they said the guy named Enoch walked with God. He so walked with God until he was not. They said that was the law. You get to the book of Deuteronomy and they say, well, the 10 commandments was not the 10 commandments on 2 pieces of tablet. They said the significance of the 10 commandments were that they were utterances and instructions. The 10 commandments were not significant because they were on two pieces of tablets or two pieces of stone. The significance of the 10 commandments was that God spoke to Moses and then Moses recorded it. Let me see. Let me see. I got it. I got it. Let me find it real quick. No. Let me see. Adam walked with God. Here we go. Here we go. Here we go. Adam, Enoch. It says Noah, Jacob, Abraham, Isaac. No. Yeah, Noah. So you got Adam, Enoch, Noah, Abraham, and I guess Isaac too. And then I think it said Jacob, but it's not pulling it up on my notes right now. But they said this was the law. Communion with God. They say if you just did what I told you to do, you wouldn't need two tablets. And then they got so disobedient that that God had to give them a secular government. They say you got King Saul as punishment, as judgment. Dang, I'm trying to find it. I ain't got it. It said Enoch, Adam, Noah, Abram. I believe Moses too, but I can't find that right now. But yeah, so all those times, what's the law? The law's not written down. You can't write it down. It's not possible. It's invisible. So they had law before they had government. That's what's the significant thing about this common law. They say you didn't need nobody to. They say, well, common law jurisdiction. No, that's you just did the common law. It was just a way of life. They said they just had the Second Amendment. They just kept that thing on them. They just, they was just ready at all times. They lived in community. They said the jury were the judges. That's just who else would it be? It wouldn't be one guy. One guy can't determine everything. He's not even from here. He don't even live here. He don't even know the people or the circumstances or the potential intentions of the heart. Why would we let one guy in a black robe determine people's life and property here? His job is to deal with foreign things. They said a grand jury. Of course, those would be the elders of the community. Who else would start a case? Who else would be wise enough to handle if something was lawful or unlawful or not? They said this is the common law. You would never have to call it common law. That's just what we called it because that's just what they called it. At one point in time, they called it the folk right or the folk law. Because it's just what the folks did. You know what I mean? Like we didn't have to have a title for everything. They didn't have a title. They were a farmer. They were minding their business. And if somebody created an injured party, then they would deal with it. Right. And then they just said they traced these principles all the way from the Supreme. Let me go to Tennessee. The Supreme Court of Tennessee says, yeah, this common law thing comes from the scriptures. So law is just history at the end of the day. Tennessee, 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 Tennessee. Excuse me. I never burp all day until I start talking on there. All right, let's see here. Look at this. The Supreme Court of Tennessee said the people have the power to alter or reform or abolish the Tennessee Constitution. They said the power to alter, reform, or abolish resides in the people, not the legislator. They said the people are possessed with ultimate sovereignty and are the source of all state authority. That's a nasty statement, y'all. I don't have no commentary on that. They said it better than I ever could. So when you live in Tennessee, you need to spread that to everybody and assemble a jury and assemble a grand jury and make sure there's an injured party or we don't hear the case. Why? Because the people of Tennessee are possessed. Ugh. That's a spiritual term, y'all. They said you're possessed with it. That goes back to in the garden with Adam, and then with Noah, and then this guy Enoch, and then this guy Moses. They say you're possessed with it. Why? Because you're made in the image and the likeness. What are you talking about? You're not sovereign. There's only one who's sovereign. We're not in control of nothing. We just plant seeds. And the Bible says you sow good seeds, good things will grow. You sow bad seeds, you'll reap corruption. Okay. Why? Because the people of Tennessee are possessed with the ultimate sovereignty and are the source of state authority. They said the guy with the badge and the handcuffs, he ain't got no authority. You know, you can go to law school for 7 years, 3 years, 4 years in undergrad, 3 years in law school, and still be subject to 12 farmers in Tennessee, to 12 moonshiners in Tennessee who determine the law and the facts. Why? Because the people, not government officials, are possessed with the ultimate sovereignty in Tennessee. The Supreme Court of Tennessee said the common law is founded on the scriptures. And they said the courts of justice cannot construe statutes that are contradicting the common law. They said the usages and continued practices of the people is the evidence of what the common law is. They said you can't write it down. It doesn't exist on paper. It comes from the utterances. That's what the book of Deuteronomy means. They said the words and utterances. He said he gave us the breath of life. And they said the common law is not repealed in Tennessee. You see, this stuff is deeper than, oh, you gotta change your status, claim the name. They said they didn't do none of that. They said they were already possessed with all the sovereignty. They said there was no pieces of paper that needed to do. They said assemble a grand jury. What is a court? A court at common law is the person in suit of the sovereign. What's that? An injured party. A real man or woman, not a statute. A statute can't be sovereign. A statute can't be violated. What they say a crime is, they say the crime is a violation of a criminal statute. Okay, that's not a crime. That's never been a crime ever. And no country has that ever been a crime. They just be making up fake stuff and say, oh, you violated this inanimate object called a piece of paper. You can't do that. They do it, but you can't do it. That's not what a crime is. Let's see. I forgot what I was talking about. Oh, common law comes from the scriptures. Yeah. So Supreme Court of Tennessee knows something we don't know, right? Tennessee got some asses though. I was almost going to get in trouble with what I was about to read. Let's see here. Let's go to Florida. Florida says the same thing. Ooh, then we're going to West Virginia. Remind me to go to West Virginia. West Virginia. Florida, Florida, Florida. The Supreme Court of Florida said every system of law comes from some religion. They said the common law comes from the Christian. It says its substance comes from the Christian ethics. Its roots go deep into that system, the Christian concept of right or wrong or right and justice. They said that's what equity is supposed to mean, not you got magical money coming to you to pay magical bills you were never supposed to have anyway. I think they said something else. Oh, West Virginia. Let's go to West Virginia. West Virginia's got nasty. I think it's West Virginia and New Hampshire. Yeah, we're going to West Virginia and New Hampshire. New Hampshire. Excuse me. Who is this? Who is this? Who is this? All right, this is New Hampshire. This is the Supreme Court of New Hampshire. They said, now they're talking about the Reformation. So Martin Luther, the 1500s, right? They're breaking off from the Pope. All right. They said, now the principles of the Reformation adopted by Martin Luther were founded upon the Bible alone, received as the revelation of God's will, and held to be the supreme and only rule of practice and faith. They said this was the doctrine of the Reformation, that the Bible alone. I'm talking about this is the Supreme Court of New Hampshire, y'all. There was a point in time in our history where our judges were righteous, that they were talking about the principles of the Bible. They don't do that today. No, sir. They kill babies. They do all type of stuff now. All right. They said this is, in fact, the doctrine of the Reformation, that the Bible alone was and was to be the only source of all true religious light and of all revealed religious truth, and that every doctrine in theology, as well as every course of life, is to be tried by this test and judged by this standard. Not the Pope, the Bible. That was the purpose of the Reformation. This is the Supreme Court of West Virginia. They said the illustrious King Alfred. I told y'all about King Alfred the other day, didn't I? King Alfred he didn't adopt anything. He compiled the laws of his day, and it's called the Dome Book. Dome, but it's spelled, no, it's called the Doom Book, and doom is spelled D-O-M-E. So it was called the Doom Book, but it was D-O-M-E, and you can't read it. It's ancient English, but you try to find commentaries on it, and they say that this thing called the Doom Book, which were the compiled laws of ancient England in his day, were based on the Decalogue. The Decalogue is the Ten Commandments explained in the book of Deuteronomy. So, because I had this case before I knew the significance of King Alfred, so that's why I'm fascinated by this. So they said the illustrious King Alfred adopted the Ten Commandments as the foundation of the early laws of England. Say common law. You see why they don't talk about the common law no more? Say the common law of England. And people try to debate me all the time. Oh, the common law, they don't do that no more. That's the reason we broke off from England, so we don't have to do the common law. You haven't read not one piece of the Declaration of Independence, dude. You have no clue what you're talking about. No clue. This is the Supreme Court of West Virginia after the Civil War. They said the illustrious King Alfred adopted the Ten Commandments as the foundation of the early laws of England. Oh, I see. I didn't read the whole thing contained in his Doom book. It's yeah, it is Doom book, but it's spelled in ancient English Dome. They said these commandments, which are like a collection of diamonds, bear testimony to their own intrinsic worth, in themselves appeal to us as coming from a superhuman or divine source, and no conscientious or reasonable man has yet been able to find a flaw in them. The Supreme Court of West Virginia, y'all, this is crazy. Talking about how the Ten Commandments are flawless. They say they used to teach this stuff in schools way before I was born. They said the Ten Commandments are like a collection of diamonds and bear testimony to their own intrinsic worth, in themselves appeal to us as coming from a superhuman or divine source. And no conscientious or reasonable man has yet been able to find a flaw in them. He said, or whoever this judge is, said they are absolutely flawless. And they said no nation or people can long continue a happy existence in open violation of the Ten Commandments. Say, we're in trouble, boys. They said this is the Supreme Court of Pennsylvania. That's under West Virginia. No, I don't have a West Virginia collection yet because I don't have enough stuff, but it's in the Bible collection. If you go to if you're on the Patreon, just go to, I think it's towards the bottom. Go to the Bible collection, and that's what I'm reading from right now. And so I forgot where I was at. Pennsylvania. All right. The Supreme Court of Pennsylvania said that Christianity is and always has been a part of the common law of Pennsylvania. They said Christianity was one of the considerations of the Royal Charter. It was the very basis of its great founder, William Penn. See, the Bible says that from one man, they create an entire nation. Okay, well, who's Pennsylvania named after? William Penn. See, they got documentaries. See, if I was from Pennsylvania, oh man, I'd be in so much trouble. I'd be the nastiest dude in Pennsylvania, because they said this guy named William Penn got in so much trouble, but they couldn't do anything. He got in so much trouble that they had they had nothing else they could do but respect it. And so I believe it was King Charles, I don't know which one, said, all right, well, you win, and gave him a plot of land. And that is now called Pennsylvania. And that all the Amish people that we know of today, what we now know to be Amish people, have been living under that same charter since William Penn came on the scene. That's nasty, y'all. So they said, the Supreme Court of Pennsylvania said Christianity is and always has been a part of the common law of Pennsylvania. They said Christianity was one of the considerations of the Royal Charter and is the very basis of its founder, William Penn. They said Christianity essentially conveys the liberty of conscience to all men. They said William Penn and Lord Baltimore were the first legislators who passed laws in favor of the liberty of conscience. And that would be the root of where they got a lot of the freedom of speech in the First Amendment. All right, this is another one. This is another Supreme Court of Pennsylvania case. They say every country has a common law. Pennsylvania's is from the common law of England. They said when our ancestors immigrated from England, they took with them such English principles. They said before the time of the Revolution, we had formed a system of our own, founded in general on the English Constitution. What's the English Constitution? The Magna Carta. They said the minds of William Penn and his followers would have revolted at the idea of an established church. That's where we would have got the principle of the separation of church and state. Because what was the established church that they were trying to revolt against? The Roman Catholic Church. So they said, yeah, you have the freedom of religion. You don't have the freedom to enforce religious ideas inside of the law and make us bound to it. That's the whole reason for the separation of church and state. I tell y'all this story all the time. In 1774, the United States Continental Congress wrote a Declaration of Rights to prepare for the revolution because the Roman Catholic Church had took over Quebec and was enforcing ecclesiastical equity law in Quebec, which is still there to this day. And so they said the minds of William Penn and his followers would have revolted at the idea of an established church as the law. They said, no, liberty to all, but preference to none. And they said, this is okay. At common law, you're free to be whoever. You just can't make us try to be all that. So if you wanted to be atheist, okay, go be an atheist. Just don't put your hands on nobody, and we won't put our hands on nobody. And there's no such thing as a crime where there's no injured party. You see how simple it would have been then? They say, yeah, that you don't establish a national religion. People are free to be whatever they think is best as long as they don't create an injured party. You want to be a Muslim? Okay. Even during the time of the revolution, there were Catholics who had the freedom of religion that was against Protestantism. Okay, as long as you don't acknowledge the spiritual supremacy of the Pope, then we didn't have a problem. Look, all of Maryland is based on Catholicism, right? So they weren't against religions. They were against making religions the law or religious ceremony the law. And that's what ecclesiastical admiralty and equity law does. Yep. This is actually the Supreme Court of New York, but they said it is sufficient that the common law, whose morals have been elevated and inspired with a more enlarged benevolence by means of the Christian religion. What else? You're like, this dude is going off the deep end tonight. They say, we just want to know how to stop paying taxes. No, I'm just kidding. Let's see, I just read that one. New York. Let me clear some tabs. The Supreme Court of New York said Christianity. Let me read it right. It's ancient English, so we got to read it right. So they say Christianity was the parcel of the law, and to cast tumultuous reproaches upon it, intended to weaken the foundation of moral obligation and the efficacy of any reproaches upon it is intended to weaken the foundation of the moral obligation and the efficacy of oaths. They said the morality of the country is deeply engrafted upon Christianity. They said to secure the people of this state freedom from coercion and equality of right on the subject of religion. So they said such parts of the common law might be construed to establish or maintain any particular denomination of Christians. Everything I've read to you thus far is on the Patreon. Yep. Yeah, so I got a little collection on the Patreon called The Bible. It's only got like 9 posts. But yeah, everything I've read to you thus far. Let's see. Pennsylvania. I got another thing from Pennsylvania. Look, this is nasty. They might flag me on this one. The Supreme Court of Pennsylvania said a malicious intention of the speaker to vilify the Christian religion and the scriptures would prove a nursery of vice, a school of preparation to qualify young men for the gallows and young women for the brothel. They said every time you speak against Christianity publicly and try to persuade people not to participate in it, would prove a nursery of vice to prepare young men for the gallows and young women for the brothel. They said no free government now exists in the world unless Christianity is acknowledged and is the religion of the country. Pennsylvania said that Christianity is a part of the common law of this state. Its foundations are broad and strong and deep. Some nasty stuff. They don't talk about this stuff today. Oh, it wasn't founded on the yada yada yada. All right. South Carolina, y'all. Here we go. Supreme Court of South Carolina said Christianity has reference to the principles of right and wrong. I just read that from the Supreme Court of Florida, didn't I? They said it is the foundation of those morals and it has grown upon the basis of Christianity. Isn't there two Christianities? I don't know what that means. They said the Christian religion is the religion of the land. It is recognized as part of, oh, they said they're talking about South Carolina explicitly. They said it is recognized as part of the common law based on Article 1, Section 23 of the South Carolina Constitution. This would have been, I don't know how many constitutions South Carolina's had, but the earlier revisions of the South Carolina Constitution. So they said, so this is nasty. Okay, let me read this right. They're talking about crimes here. Watch this. So they said Christianity, the Supreme Court of South Carolina said that Christianity has reference to the principles of right and wrong. It is the foundation of those morals. It has grown up upon the basis of Christianity. They said the Christian religion, the religion is the religion of the land, and it is recognized as part of the common law based on the South Carolina Constitution. They said crimes are classified into mala in se and mala prohibita. What gives them that character? They said we cannot answer as the Israelite would do by pointing to Mount Sinai and saying, the Lord God commanded us, saying, thou shalt not kill, thou shalt not steal. The authority of these divine precepts come to us through Christianity. They said again, our law declares that all contracts contra bo mores are illegal and void. What constitutes the standard of good morals? Is it not Christianity? There certainly is none other. They said in the courts of South Carolina, we daily acknowledge Christianity as the most solemn part of our administration. They said the books of the New Testament, which testify to our Savior's birth, life, death, resurrection. This is so common a matter that it is little thought as an evidence of what part which Christianity has in the common law. South Carolina. Where was I going to go? I was going to go to the Supreme Court. The federal Supreme Court said the 13th century commentators found that the privilege against self-incrimination is grounded in the Bible. They said the principle that no man is to be declared guilty on his own admission is a divine decree from the book of Judges. You see why they don't talk about this common law? I forgot what state it was. Arkansas. Actually, I probably just had it. Arkansas, Arkansas, Arkansas. There they go. They said, no, we don't like you talking about this Christianity stuff. The Supreme Court of Arkansas said that man's laws being strengthless before God's laws. Consequently, a human law contrary to the law of God would be an absolute nullity. That's the Supreme Court of Arkansas, y'all. They said there's such thing called God's laws. They said man's laws are strengthless. They said this thing called equity, strengthless. Commercialism, strengthless. They say they are in direct contrary. They are directly contrary to the law of God, and that man's laws are an absolute nullity. Oh, that's nasty. Arkansas, Supreme Court of Arkansas. All right, what else? What states are we from? Let's see. There was something I wanted to read. Is anybody on YouTube? Nobody is on YouTube. Oh, there's 3 people. There's 2 people because I'm also watching. So, what's up, YouTube? You probably can't hear me. They be muting my stuff so bad. Let's see here. What are we going to talk about? Let's read some stuff from the Magna Carta. I read this, I think, yesterday, but I'll read it again. They said it is clear that the common law is the foundation of that which is designated as due process of law. So every time you hear due process of law, it only comes from one type of law, and that is the common law of England. So they said it is clear. It's not up for debate. Every time you hear due process, it better line up with the common law of England. They said it is clear that the common law is the foundation of that which is designated as due process of law. When first adopted in the Magna Carta, the phrase law of the land had reference to the common and statute law then existing in England. And when this thing called law of the land is embodied in the constitutions of this country, what constitution? The North Carolina Constitution, the South Carolina Constitution, the Texas Constitution, the California Constitution, the Maryland, the New York Constitution, and the federal Constitution. They said when the law of the land is embodied in constitutions in this country, it referred to the same common law as previously modified in the Magna Carta. They said at common law An arrest could not be made without a warrant for an offense less than a felony and except for a breach of the peace. They said the judge was wrong in telling the jury that the arrest laid in the second count of the indictment was a lawful arrest. They said the arrest having been made by a policeman without a warrant when there was no disturbance. They said it is legal for peace officers to arrest for offenses less than felony without a warrant. They're asking a question. I read it wrong. I'm sorry. It says, is it legal for peace officers to arrest for offenses less than a felony without a warrant and when there is no disturbance in view? It is not. They said, in cases of a misdemeanor, his presence and for which he cannot lawfully arrest without a warrant, the officer should have the warrant in his actual possession at the time of making the arrest. So they can't make an, I mean, I know they do it. I'm just telling you, they're not supposed to do it. Can't make an arrest without a warrant because at common law, what they say, at common law, an arrest could not be made without a warrant for an offense less than a felony. So if it was less than a felony, it had to be for a breach of the peace. And what's a breach of the peace? So we got to know these things. What's a breach of the peace? Violence, that's it. I actually forgot what I was going to with that. Let me see. Let me search arrest. The Supreme Court of Illinois said that under the common law, see, they always say it. They always say it like it was way back in the day, like they're not supposed to be doing it now. Like, oh no, that's how they did it then. No, that's how you're supposed to be doing it right now. The law of Illinois is the common law of England. They said under the common law, constables and watchmen were authorized to arrest felons. They also had authority to make arrests without warrant in cases of misdemeanor, which involved breaches of the peace committed in the presence of the officers. So they said policemen were unknown to the common law. A felony, also violence. No. They said to arrest felons without a warrant. Okay, the reason a felony is stealing or damaging property. That's what was considered a felony at common law. I actually have to do a little bit more research on that, but a felony always involved an injured party. So somebody got their stuff taken of a certain value or somebody's property got damaged. So that's what a felony was at common law. I remember I read that. It meant a breach of the peace meant violence, and a felon meant somebody who stole or damaged property primarily. And they could do both of those things without a warrant because a felon always required an injured party. There's no such thing as a felony where there was nobody who had something stolen from them or had their property damaged. So, but they said there was no such thing as a policeman at common law. They said that a constable or policeman has no authority to make an arrest without a warrant. And that warrant is so much stuff we got to study, but that warrant is always commercial. That is a commercial term. That word, actually, I have it. uh, is from commercial shipping. That is an ancient maritime commercial shipping word. Warrant. Yeah. A warrant is a maritime term governed exclusively by an admiralty court. They said, oh no, I said that. A warrant is a document certifying that the holder is entitled to collect goods at a maritime dock or warehouse. A warrant of arrest is a legal writ issued by a admiralty court that gives the authority to detain a vessel to secure a debt or claim. And then they got this thing called a warranty. A warranty is a contractual term where the charterer guarantees a specific condition, for example, that a vessel can always safely reach and depart from the place where cargo operations are conducted, irrespective of conditions like congestion or tides. So it always meant that word warrant always meant a contract, an admiralty maritime contract. And it's always issued by an admiralty court. So there's no time where there's such thing as a warrant that doesn't attach to admiralty. Does that make sense? So you start getting the picture. You're like, okay, well, the only time they could issue a warrant if there was a contract that somebody supposedly breached. So it wasn't possible to make a warrant on these issues. So the only time they could put somebody in handcuffs was if they damaged or stolen somebody's property, called a felony, or for a breach of the peace. They were duking it out, shooting it out, causing riots, whatever. All right. So those are the only two times that you could be put in handcuffs, according to the law. And so they said, oh, an arrest. So a warrant is not part of the common law. No, absolutely not. A warrant is a commercial term, and commerce is always 100% connected to admiralty. It is a document. See, they act like it's three different things, right? They say, oh, well, a dock warrant is a document certifying that the holder is entitled to collect goods at a maritime dock. Okay, then they got this thing called a warrant of arrest, which is a legal writ issued by an admiralty court that gives authority to detain a vessel to secure a debt or claim. And then I'm trying to say this right. So you know how they have a root word? Well, sometimes the root word is the bigger word, not the littler word. So the root of the word is warranty, and warranty is always connected to commercial shipping. So it's like a warranty if you bought an electronic and it malfunctions, right? Okay, well, you can go back to, I guess, wherever you got it from and make a claim that this thing is not working properly. And they will go over the terms of the contract and issue a supposed remedy based on the contract, right? So you buy a laptop and you got a 1-year warranty. That's all the same. I can't explain it good, but that's all the same concept. It's all based on a contract. But the issue in America is they aren't lawful contracts. So they're making fake claims as though they're valid. They've never been valid because a warrant is always related to ships or property. A warrant has never been made. An arrest is not a common law term. There's no such thing. Just like a crime. A crime is not a common law term. They called it a breach of the peace. Remember, after 1066, William the Conqueror brought in Romanism. At first, it came in seed form, and then over the years, it grew into a monster, right? So, uh, so you read all these cases where they're talking about, oh yeah, you couldn't be arrested if you didn't have a warrant. Well, no, almost nobody had a warrant created on them. A warrant is only based on a contract. They couldn't just create warrants. Technically, the only warrants would be from actual corporations, which were always coming from another country. So yeah, they say arrest shall not be made without a warrant. So arrest was always connected to a warrant. So that's not a common law term, and a warrant is not a common law term. They said except for felonies and for breaches of the peace committed in the presence of an officer. They said if he didn't see it, he couldn't make an arrest. That would constitute a false imprisonment or an unlawful arrest. This stuff goes deep, y'all. They've been lying to us about everything. Well, they didn't incorporate all of us. It's never been valid. We can't speak as though these things are valid. Oh, that's why they didn't do anything. It's a fake piece of paper. It's not valid. It's not real. There's nothing on the other side of it. But I watched this video. I talked about this the other day. His name is Alan Watts. He's some old dead guy. And he said he was talking about some, I don't know what he was talking about. I don't know what he's talking about, but there was a sentence he said that stood out to me. And he said, well, there's no such thing as an agent. And I said, he's like some philosopher or something like that. Some old dead guy, some philosopher. Everybody loves him apparently. And so he said that there's no such thing as an agent. I said, you know what? If you think about it, there isn't. There's no such thing as a agent. It's some guy believing he has the power to do something, and then he's the one doing it, not the badge, not the handcuffs, not the supposed authority. He kidnapped somebody. He falsely accused somebody. He's not an agent on behalf of somebody. There's no such thing as an agent. This guy, John, said that I committed a crime with no evidence. And same with these other issues that come from the District of Columbia. They say you willfully failed to file. Well, you've never seen me in your life. You falsely accused me. And you got this fake information from a computer that can't testify in court. So you don't know if I willfully did anything. You've never seen me in your entire life. A computer told you I didn't do something, but you've never seen me, and you don't know the intentions of why I did or didn't do something. So there's no such thing as I willfully failed. You've never even heard of me. You would never heard of me if it wasn't from this inanimate object called the computer. A computer is not evidence that is admissible in court. Just like a birth certificate is not evidence that is admissible in court. A social security card is not evidence that is admissible in court. All these things we believe are real are not evidence. Evidence is always based on sensory perception. And if the first time I see you is when you falsely accuse me of something, oh, well, then I know you had no evidence. Because evidence is that Thomas put his hands in the holes of the resurrected Christ. And he said, oh, yeah, now I know this is the one. They said 500 people saw the resurrected Christ walking around. And it went so viral that they had to execute people to stop talking about it. Because for the first time in history, since the book of First Samuel, they no longer needed government anymore. And the people who believed they had power were so annoyed by the fact that they didn't have to rely on them anymore that they had to execute people over the issue. There's no such thing as an agent. There's a guy who falsely That's what clinically insane means. That you believe a computer could tell you something, and then you go and accuse a real man or woman of something that you've never even seen them in your entire life. You say, "Oh, this computer told me." A computer told you? That's not evidence. I tell you all the time what evidence is. The word evidence comes from the root word vid. Vid is from the Sanskrit language. Sanskrit is an ancient India language, like India over there in India. You know what India is, right? So before they said this was between 1200 and 1500 BC, they had this word called vid, and they had this word called video, and they had this word called evidence. And that word vid, which grew to all these other terms, meant to look upon, to see. So they had video before there was such thing as a camera, before there was such thing as TikTok and live stream. They had videos in 1200 to 1500 BC. And so it would be crazy for me to say I'm talking to 12 people on TikTok. That's considered crazy. I'm talking to a block of electronics. I'm talking to a empty room right now. You know how crazy that is? If I ask you if you saw the football game or the basketball game and you weren't in the stadium, that's not admissible in court. You say, "Oh, I saw it on yeah, I saw the game. I saw it on the TV." No, you didn't, because that's not video. That's not evidence. Yeah, but I saw it on the TV. No, that's not seeing. You looked at a wall projecting an image that is not admissible in court. It cannot testify against you. How many times people get pictures of their license plate and they say, "Oh, well, the picture is evidence." The picture's never been evidence, ever. A photograph cannot testify. A computer system cannot testify. You know how crazy that is? That's like I say, you violated a statute. A statute can't be violated. What do you mean? Yeah, I violated a statute. A statute is not real. It's an inanimate object. There are only people, there are only men and women, and there are injured parties. Did I put my hands on somebody? Did I take something that did not belong to me? Okay, well, those are the only things that you're supposed to be brought into court over, because everything else is fake. It's not real, right? So somebody said, so a warrant on a computer. You have a warrant on the computer. Right. There's no such thing as a warrant on a computer. A warrant technically is just a piece of paper signed by a judge. And it has to have not a stamp, but it has to have a pen stroke as though somebody actually held a pen and wrote a signature. They put people in handcuffs over something they saw on the computer, y'all. That's not a warrant. So me too, we ignorantly believe all this stuff is evidence. None of that stuff is evidence. It's not real. What do you mean? The radar told, did the radar tell you that? Did the statute tell you that it was violated? Yeah, there's no such thing as violating a statute. They tell you, look, ask an attorney. They'll say a crime is violating a criminal statute. Well, you can't violate a statute. There's no such thing. There's no such thing as a statute, y'all. It's a fake piece of paper. And a statute can't testify in court. Is the statute here with us? We'll put the statute on a stand. You know what I mean? Like it's all made up. It's all fake. It's all fake. They say we got video of you do you, that's not admissible in court. What do you mean the video? You got video? That's not what video is. So they got facial recognition and They got these things. You go to the airport now, they got you, they don't want to see your passports no more. They want you to put your face in the thing. They want to confirm that you're real. That's a camera. A camera's not real. A camera can't verify that I'm who I say I am. Do you not see a man? Somebody I seen some nerd on the TikTok say that. They say, "Do you not see a man standing in front of you?" Like, none of this is real, bro. What are you talking about? They want you to believe all of this is real. Technically, I'm not. I'm in a. This is crazy. This is the Amish people call this stuff witchcraft because I'm literally in a room by myself, just talking to a wall. So you start peeling back the layers of fabrication, and you'll get to reality. When Christ was resurrected, he said he fulfilled the law, y'all. He said all of the law is concerning me. So when he resurrected, they didn't have to go to Caesar. They didn't have to go to Rome. They didn't have to go to Pontius Pilate anymore. Remember, Jerusalem and all the known territories were under Roman control. And when he resurrected, they said, we don't have to go to this to get our answers solved anymore. He said, no, this is it. I am he of who it was spoken of by the prophet Isaiah. They said, yeah, they don't, the first 10 books of the Bible, they had no government, y'all. No government, but they had law. And they wouldn't obey the law, and they couldn't obey the law. So he gave them a fictitious government. He gave them King Saul. King Saul was horrible. Everybody agrees. Atheists agree. The Christians agree. King Saul was awful, was horrible. You get to King David, he started real good, ended horrible. Killing people, sleeping with other people's wives. Okay. Then you get to King Solomon, horrible. Ruthless, horrible. And then that's the start of secular government. They introduce paperwork, all these fake traditions, all this fake ceremony, all this fake stuff. And then God would raise up a prophet and say, hey, this is kind of garbage, y'all. You should probably stop this. And then he would raise up prophets and say, hey, this is kind of garbage. You probably should stop this. They wouldn't stop it. They loved it. People ask all the time, well, how did the people of God wander in the wilderness for 40 years? Go look outside. This is how they did it. And then you get to Christ and he fulfills the law. He obeys the law. He kept the commandments, the same ones that Abraham had before there was such thing as the 10 commandments. He taught the 12, the law and the facts. He paid the ultimate sacrifice. And then when he was resurrected, the law was fulfilled. And they didn't have to rely on government no more. He said, all right, I'll be back. Peace out. And then the governments of the day said, oh crap, how do we keep control of them? They said, we got to erase this dude from the books. We got to erase all the supernatural stuff from the books, create these things called universities, and we'll put these people called atheists there. And we'll create this thing called science, and that'll be the explanation of all this stuff. Come on, man. They lie straight to our face every day. You know, they got this thing. I got a book. I don't know. But they talk about the medicine. They said the first time medicine was introduced was in Rome. That's probably not the first time, but you know what I mean. So they say in Rome, they got this thing called pharmakia. Okay, that was a Greek or a Roman term. Okay, that's where they got what we now know to be pharmacy. Okay, well, pharmakia was considered witchcraft because it mixed a bunch of chemicals to try to solve flesh or, you know, sicknesses and ailments, but it always had side effects. And they said before that stuff, people would just eat, you know, what they call herbs. The Bible says that herbs are for the healing of the nations. And so they say you could just change your diet or rearrange your diet and eat certain herbs, stuff we probably don't even know exists no more and probably don't exist no more. And that would heal you. You wouldn't have to go to the pharmacy or the pharmakia. That was the first term of medicine, what they call medicine today. Why? Because when Christ resurrected, you didn't have to go to these things anymore. Somebody said it earlier. He said he'll write the law on your hearts. The Apostle Paul said that the law is a tutor that leads us to Christ. See, Christ said, all the law is concerning me. And then you get to the New Testament, and Paul says, yeah, the law is a tutor. It'll take you back to the source, the lawgiver. He said, before Abraham was, I am. He said, who do you think was walking with Adam in the book of Genesis? He said, that was me. He said, who do you think was walking with Enoch? They said he walked with God. Well, God doesn't walk, does he? Yeah, his name is Christ. He said, who do you think was walking with Noah? Who do you think spoke to Moses and gave him the law? It was me. And then you get to Apostle Paul. Apostle Paul says, yeah, the law is the tutor. It's the thing that will lead you to the one. They said, we didn't get rid of the law. What are you talking about? The law is here. His name is Christ. He resurrected. That's the law. And they say the Supreme, I just read it to you all night. West Virginia, Tennessee, Arkansas, Florida. They say, yeah, this thing called the common law, the English laws. Yeah, they come from the scriptures. I got a book that say the Anglos and the Saxons said they can trace their history back to the people of Moses. So where'd they get it from? They got it from Christ. Well, yeah, that would have been after the resurrection. So yeah, they said at common law, you can't just put people in handcuffs without a warrant. A warrant would only be a commercial term. They said without a warrant for a misdemeanor. They said at common law, the right to arrest for a misdemeanor is limited to those offenses which amount to a breach of the peace. They said an arrest without a warrant is permitted only for the immediate preservation of the public peace. And accordingly, when the public peace is not menaced, which is a physical term, a warrant is necessary. They said people didn't get arrested like this. First of all, there were no jails. There was only like 2 jails when the country started. I think there was one in Boston, and I think there was one in Philadelphia. I think that was it. They said those are the only jails in the country. And I tell you all the time, you need to look up the original map of the 13 states. Those maps were huge. New York went all the way to what is part of Ohio now. Virginia went all the way to what is now known as Kentucky. North Carolina went all the way to what is known as Tennessee. And they said there was only 2 jails and prisons. One in Boston, one in Philadelphia. They said only if the issue is committed in the presence, a misdemeanor committed in the officer's presence are arrestable without a warrant. Here we go. New Jersey said the roots of the common law for the protection of personal liberty against illegal arrests. They said the limits to the power of arrest by a constable without process was well defined at common law. So they didn't call it arrest then, they called it process, which is a commercial term. They said the law, this is another Supreme Court of New Jersey case. I don't know if it's a Supreme Court of New Jersey, but it is a New Jersey court. They said the law did not allow him, the constable, to exercise the function of whether or determining whether there was a sufficient cause of the violation of the law to justify an arrest. They said, we're not here over fake statutes. You can't just be putting people in handcuffs. And you don't get to determine if he broke the law or not. If there wasn't an injured party that went to you and you didn't have an arrest warrant that came straight from the judge to tell you to go get this dude, okay. And you didn't see him commit a breach of the peace in your face, that dude got to go home that night. It's crazy, y'all. You know how many people are in jails and prisons right now who never put their hands on nobody, who never touched nobody else's property, but because of a fake statute that cannot be violated, they put people in what they call a warehouse. Who is this? This is a law book. They said when he arrests a person without a warrant, he transcends his authority as an officer and lays himself liable for damages for false imprisonment. They said an officer has no right to arrest without a warrant. And I don't know if I can say this, but they said this was over the issue of being a prostitute. They said they said you can get it how you live. We can't put our hands on you. Now, we're not promoting that. I'm just telling you that was the issue of that case. Wisconsin said, now this is nasty. They said, based on this thing called due process, which comes from the Magna Carta, they said due process of law conveys every right to which a member of the body politic is entitled under law. They said this thing called limbs are equally protected with the life, and the right to the pursuit of happiness and any legitimate calling or occupation is as much guaranteed as the right to go at large and move about from place to place. They said the deprivation of life and property were prohibited by the Great Charter. What is the Great Charter? The Magna Carta. This stuff is nasty, y'all. That's the Supreme Court of Wisconsin. They said an arrest without a warrant has never been lawful, y'all, except when public security requires it. They said an officer is not permitted to make an arrest without a warrant for any misdemeanor. How many? Any. They said again, Wisconsin said at common law, arrests were not permissible without a warrant, except for acts committed in the presence of an officer causing a breach of the peace. Let me go to North Carolina. Oh, let me read this one. No. Well, yeah, this is the Supreme Court of Louisiana. They said there's a distinction between false imprisonment, which is the detention without color of legal authority, whereas malicious prosecution is any detention which is malicious but under due forms of law. So they said false imprisonment is detention without color of legal authority. Is there one for Texas? Let me see. I may have it, but I may not have it immediately available. Let me see. Yep. There's a lot. I'm not going to read all that. But they say the Supreme Court of Texas says false imprisonment is the willful detention of another against his consent and where it is not expressly authorized by law. Such detention is to be affected by an assault where by actual violence of the person or by threats, say injured party, by which restrains the party so detained as he may see proper. All right, let me see. That was another one. That was false imprisonment, arrest. Here we go. Supreme Court of Texas. Actually, this is not. This is an appeal court in Texas. Says an arrest without a warrant is unlawful. They said they can't arrest nobody if it wasn't against the public peace. And this is what they've done. I'm finna go to North Carolina because North Carolina explains it really good. Y'all better join the Patreon. It's $5. All these books, everything I'm reading you can have access to right now. North Carolina, North Carolina, North Carolina. They said false imprisonment is the unlawful and total restraint of the liberty of the person. This right is violated. This right violated is a tort of the freedom of locomotion. It's at the top of my TikTok page. You just click the link. The Supreme Court of North Carolina said an arrest should not be made without a warrant. An arrest without a warrant is deemed unlawful. They said this is the foundation principle of the common law. They said more than a trial by jury. They said we wouldn't have to assemble a jury if you didn't put people in handcuffs without a warrant. This saves the country money. They said this is a foundation principle of the common law and it is of ancient origin. They said it derives its assurances from the Magna Carta that no man should be taken into custody of the law without the sanction of a warrant or other judicial authority. They said these exceptions relate to cases involving felonies and suspected felonies and to breaches of the peace. And let me actually go here because that case actually explains. I need to add that. Violence constitutes a breach of the peace. Say violence constitutes a breach of the peace. Violence. A breach of the peace is a public offense done by violence. Injured party. Say injured party. Injured party. They said a breach of the peace is a public offense done by violence or one causing or likely to cause an immediate disturbance of public order. A breach of the peace means violence. Violence. They said you could not be put in handcuffs if there was no warrant and no violence. They do it every day, don't they? They had a TV show about it called Cops, where they just put people in handcuffs. Oh, y'all remember I got that Texas case where they said speeding and running red lights were not breaches of the peace. Let me see if I can find it. It's Texas. Let's go to Texas. I forgot about that. I keep forgetting that case. See, I had that case before I even knew about this stuff. Yeah, this common law thing nasty. That's why they don't talk about that common law, y'all. We're not crazy. They really not talking about it. Oh, come on. Let me see. Now you can't find it when you need it. It's going to be in criminal law. Let me clear out all these freaking tabs. I was supposed to be talking about the Magna Carta. But this is all talking about what's in the Magna Carta. Criminal law. Let's see here. Breach. Dang it. Now I can't find it when you need it. Let me see if it's in my book. No. Do I have a list of all those cases, Rolodex, ready to share? Kinda. This is the Patreon. This is literally, I'm just reading from the Patreon. Everything I post, uh, everything I find related to one of the 50 states or a constitutional or common law topic, I put on the Patreon. So I'm literally just searching the Patreon right now. So right now I'm in the criminal law collection. So everything that I find that's related to criminal law, I've compiled that as best as I can to the common criminal law section of the Patreon. So if you go to the link at the top of my page, you'll see, all right, I don't have all 50 states, but I got most of the 50 states. And then I got, let's see, I got PDFs, so dictionaries, books, all that stuff. And I got a common law section. I got a US Constitution section. I got a criminal law section. I got an admiralty and maritime section. I got a state sovereignty. I got a land patent section. I got a courts section. I got a bank section. I got a money section. I got a passport section. I got a revenue law section. I got an equity section. I got an employment section. I got the feds section. I got social security numbers. I got a homework section, jurisdiction, the Magna Carta, maxims of law. All these may not be great. A lot of them are. And then I'm as I find things for the different states. I got Alabama, Alaska, Arizona, Arkansas. I got most of the states on there. Then I got, like earlier tonight, I read the Bible section. I got a post office section. I got the bear arms section. I got a sheriff section. I got a citizenship section, a right to travel, different things. As I find things, I try my best to categorize it and throw it in that category. They call them collections. But man, I know I got that case. It was a Texas case. They said speeding and running a stoplight or a stop sign or something like that were not breaches of the peace. And it was a Texas case. So what I would do if you join the Patreon, I'd take one day a week and I would copy and paste one collection to a Google document. Like, hey, if the Supreme Court of your state said this, okay, well, I got a Texas Google Doc and I'm just going to copy and paste everything and I'm going to download all the books. I would have a flash drive or a, what they call it. Oh, boom, beautiful, got it. Ooh, 1, 2, 3, 4 cases. Let's go. See, I be forgetting I got stuff, y'all. This is nasty. All right. Texas said this dude was speeding and he ran a red light. They said the reasons for the initial detention speeding and running a red light are not breaches of the peace. Okay, well, what are arrestable offenses, y'all? They said this was this thing called the initial detention. This is before I learned anything about false arrest and imprisonment. They said the only way you can arrest somebody is for a breach of the peace. I had this case for years, didn't know what it was talking about. Yeah, not a breach of the peace, whatever that means. Yeah, that's the only thing they can arrest you for is for a breach of a peace when there is no warrant. So I think this case, this dude, I forgot the whole story, but I think he let's just say he robbed a gas station the day before. Okay, well the next day they saw the dude driving around and they pulled him over without a warrant. And they told the court that the reason they pulled him over was because he was speeding and running a red light. And then the judge was like, yeah, you should have came up with a different reason. You can't be arresting people for speeding and running red lights because that's not a breach of the peace, which is a common law term, which is the only arrestable offense. And that breach of the peace means what? We just read it. Violence. See, they be lying straight to our face, y'all. All right, here's another case from Texas. They said they found no breach of the peace when a car sped through a red light at 3:30 in the morning. Come on, y'all. They be lying straight to our face every day. And the scammers on TikTok, they don't be talking about none of this stuff. They ain't got no information. They said this is another case. So one was from the 1990s, the other one was from 2000s. This one's another one from the 1990s. They said, yeah, the reasons for the initial detention were for running a red light and speeding, which we're not advocating. I'm not advocating running red lights. We're not advocating speeding, but those are not breaches of the peace. You know how nasty that sentence is? You know how many people they just put in handcuffs because they got in a high-speed chase, got in no accidents. We're not justifying it, but they got in no accidents. They caused no harm, no damage, and they straight put them in handcuffs, put weapons in their face. Or some dude ran a stoplight at 3:30 in the morning and they pulled them over when they are not supposed to be pulling people over for running red lights and speedings. So they say again, this initial detention, because you study the law of arrest and any amount of pause. That word arrest, it is a maritime commercial term. It's also a medical term, which is also a part of the civil law. Arrest means any form of stoppage. When you go into the cardiac arrest, okay, what happens? An artery or something is not beat, it's irregular, it's stopped, it's slowed down, it was held, it was halted from doing what it would normally do. So they say, okay, well, you're not supposed to be arresting people, even if they don't put you in handcuffs. That's any form of stopping. If there was no warrant and there was no breach of the peace, even if they call it a felony, even if they call it a misdemeanor. Oh man, this stuff is so nasty. All right, this is in the right to travel collection. Okay, I put it somewhere. I put it in the wrong one. Let me add it to the criminal, and then we're going to add it to the Texas and because they got a California case I'm about to read. So we're going to put it in the criminal law section. And we're going to put it in the Texas. Okay, we passed Texas somewhere. There's Texas and California. There we go. Everybody should have got a notification who is on Patreon about it. All right. And then now the Supreme Court of California said it is questionable whether the legislator considers an infraction to be a crime. They said this penal code, which deprives a person of a right to a trial by jury, both of these rights are guaranteed to one accused of a crime by the California Constitution. I don't know what that has to do with speeding and running red lights, but I added it there for some reason, but it's there. Oh, because they call it a crime in the penal code. So they arrested a dude, they deprived the person of his rights, because they called the penal code a crime, which all penal codes in California relate to non-criminal offenses. There you go. The more you know, you got to read the case. This stuff is nasty, y'all. This stuff is nasty. Because they'll look you dead in your face and say, no, it's a crime. You got to go to jail for it. What? They say a crime is a violation of a criminal statute. Nope, but you can't put people in handcuffs over it. All right. Yeah, so breach of the peace, that's what we was talking about, right? Let me go back to that case. Violence constitutes a breach of the peace, which authorizes an arrest without a warrant for the breach of the peace. So violence. They say it again. A breach of the peace is a public offense done by violence. See, they'll lie straight to your face, boy. He said it is common knowledge to such conduct on the public street in the presence of others that provokes and incites immediate violence. I got some. Let me see. Dang, this case is nasty. All right. So, yep, that's what a breach of the peace is. It is violence. And then you go to the definition. That's what I was talking about. Let's search breach of the peace again. So they use the word crimes, and I haven't studied the word crime like I should have, but that's what they want you to make it seem like the word crime is the worst thing ever. So they say, "Oh, a crime, a crime, a crime." They villainize that word crime, and I'm not advocating people commit crimes. Obviously, I'm saying they use that word to blanket every action that they write to justify them putting people in handcuffs. See, at common law, they didn't call them crimes. They called them breaches of the peace. Because if you minded your business and you didn't put your hands on nobody, okay, well, you were never arrested in ancient England. Breach of the peace. So let's go back. So we read Louisiana. All right. So what's the definition of a breach of peace? In criminal law, it is an offense against person or property when accompanied by violence. They said the definition of arrest in criminal cases is in criminal cases. Okay, well, what offenses an arrest may be made for a breach of the peace or for a felony? They say a constable may freshly arrest one who has committed a breach of a peace, and they are to carry him before a magistrate. What else? We were talking about arrest. That's what I was searching. We were talking about arrest. An arrest. So let's search arrest again. And they say unlawful arrest in Illinois, New Jersey. We read the law of arrest. They said when he arrests a person without a warrant, he transcends his authority as an officer and lays himself liable for damages of false imprisonment. They say an officer has no right. How many rights? None to arrest without a warrant. They said that we talked about Wisconsin. They said this comes from the Great Charter, the Magna Carta. They said nobody, they limbs are equally protected with the word life in the Magna Carta. They said this word is deep. They said an arrest without a warrant has never been lawful. Who is this? Louisiana. We read Louisiana. They said an illegal arrest is assault and battery. It is an assault and battery because the person attempting to be restrained of his liberty has the right to use the same force in defending himself. Ooh, don't tell him that. Supreme Court of Florida. A constable at common law cannot arrest without a warrant. They said a statutory misdemeanor. What's a statutory misdemeanor? What they wrote down a fake law, is not such an offense that authorizes an arrest without a warrant. Oh boy, don't tell them that. They said a sheriff and his deputies have no right to make an arrest of any person without a lawful warrant, except the person who has committed a felony or is engaged at the time in a riot or unlawful assembly or is about to commit a felony. But then now, because time has gone, now they think they can disregard the old principles. So now we got to know the word felony because they call everything a felony now, right? But they get away with that because of our ignorance. It's our fault. It's our parents' fault. It's our grandparents' fault. Somebody dropped the ball. Virginia, at common law, a peace officer may arrest without a warrant for a breach of a peace, but for no other misdemeanors. A police officer who exceeds his powers in making an arrest without a warrant becomes a trespasser, and a person may lawfully resist an illegal arrest. Don't tell him that. Don't tell him. Rhode Island, no officer had authority at common law to arrest without a warrant. West Virginia, at common law. They always say at common law like it's way, 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 way back then. Nope. That's today. They're not supposed to be doing it today. The law of West Virginia is the common law of England. The law of Texas is the common law of England today. They said what constitutes a lawful arrest? No one can make a lawful arrest for a crime except who has a warrant issued by a court or magistrate. And they cite they cite so many cases, I can't even count them. Michigan, New York. I don't know. I guess that's a federal case. Vermont, Connecticut. They said it is a general rule of law that there can be no arrest. This is a law book. They said it is the general rule of law that there can be no arrest without a warrant. They do it every day, y'all. Oh man. They make TV shows about it. They make fake TV shows, then they make like cops and stuff like that where they just be putting people in handcuffs, pulling them over. They put it right in their face. You watch whatever hot TV police show is out today, they be putting people in handcuffs with no warrant. All in our face. Yeah, we don't do that common law stuff. They'll make a super cop movie and everybody will love because he's the hero. That Joker's the villain. He be shooting people. He be putting people in handcuffs, beating them up. No warrant at all. No breach of the peace. Mississippi. Mississippi said at common law, the officer was not authorized to make an arrest without a warrant. They said by the common law of England, neither a civil officer, or a private citizen had the right without a warrant to make an arrest. They say even if you do make an arrest, whether it's lawful or not, you're still supposed to take them directly to a magistrate. They let people sit in jail for days, bro. Days, weeks, ain't seen nobody. They said an arrest without, Texas said, we already read it, but an arrest without a warrant is unlawful, as the offense charged is not a felony or against the public peace. Michigan, if a person can be restrained of their liberty and assaulted and imprisoned without a warrant, there is no limit to the power of a police officer. There you go. That's what we're living in. They said in another case, so far as arrests are concerned, our system, we have repeatedly decided that no arrest can be made without a warrant, except for a felony or the breach of the peace committed in the presence of the officer. Oregon, they're going to say at common law. They said it must not be forgotten that there can be no arrest without due process of law. It was a rule that an officer had no right to arrest without a warrant. Yep. Any questions? Any questions? You see why they don't show my stuff to nobody? They said, don't tell them this. One 19 or 20-year-old gets a hold of this information and starts making TikToks that can go viral on it. Boy. Any questions? Any questions? Alabama. So you can file a claim in federal court for an unlawful arrest no matter how old it is. I don't think you can do that no matter how old it is. It has every court, because if you go into a federal court, it is a commercial court. That's all they do is admiralty. So, but every court and every appeal has a time period. So you would have to figure out what the time period is from your nearest court or your nearest federal court to appeal a judgment. So I don't know that answer off the top. Alabama, at common law, an arrest could not be made without a warrant. New York, it is well settled that the power to arrest without a warrant, an officer has no such powers in cases of misdemeanors. South Carolina, we already read that one. Maine, like I said, you get to the top of the country, They said they got this thing called due process of law and the law of the land, which have their origin in the Magna Carta. And they say the statute has not changed the rule of the common law. It has been held that the authority of an officer to arrest for a misdemeanor without a warrant is limited. Georgia said the same thing. False imprisonment at common law is the unlawful detention of another for any length of time. That's what I was talking about earlier. For any length of time. They pull you over, that's a length of time. They asking for stuff where there's no warrant and no breach of the peace. That's a length of time where you are deprived of your personal liberty. They say they're not even supposed to be turning on their emergency lights if there's not an emergency. They do it every day, don't they? Yeah, they say we don't do that common law stuff here. We're here to get that bread. All right. Well, I'm gonna get off of here. Tomorrow, 6:30. Tomorrow, 6:30. No arrest without a warrant. No arrest without a warrant. Unless there was a breach of the peace. And a breach of the peace always means violence.